Mode.
Good afternoon, my name is Jeanette Camping, Conference Manager at Henry Stewart Conference Studies. I'd like to welcome you to the latest in our series of continuing education webinars with today's topic, High-End Residential Real Estate. We are delighted that so many of you could join us today with over 150 property professionals registered for the webinar. At the end of the presentation, we will take questions, so please feel free to send them through via the chat bar, and our presenters will answer as many as possible in the time available. After today's session, you will receive a link to the recording of the webinar. It's my great pleasure to welcome our presenters, Elaine Dobson, Alistair Watson, and Lawrence Cobb from Taylor Wessing. Thank you for joining us today, Elaine.
Hello, my name is Elaine Dobson. I head up the residential property team here at Taylor Wessing. My talk will give an overview of the market in the past year, and then I'll move on to who is buying, what and where, and highlight the themes we are seeing as lawyers, the complications, and if there are any, some solutions. So if we start with the market overview, both Savills and Knight Frank have issued extensive research at the beginning of this year and at the end of last with regard to the market in 2014-15. This shows a rise in capital values in most price level years with a softening in the prime London market and a fall of around 0.1% in the first quarter of 2015. The growth rates have been strongest in the City of London, Islington and on the Hyde Park estate in central London. It's generally accepted that the first half of 2014 was far more active than the second half. However, market researchers are still bullish and predict a rise of between 23 and 25% in prime central London prices over the next 5 years. The latter half of the year showed a marked reduction in stock levels and a slowing down of price rises, principally due to various factors, these being a lack of stock, and by that I mean a lack of quality stock, which could be just the correctly priced stock. As we've seen, early 2004 saw a rapid rise in prices, and some vendors still have unrealistic expectations of the price that they will achieve. The SDLT changes in December 2014 took most of the market by surprise, and the slab SDLT levels have impacted those purchases above 1.25 million. It must be remembered that any increase in SDLT has to be found from equity or from cash, and from our experience it is the vendor who's taking the burden of the rate rise by reducing the asking price for the property. The mortgage affordability test, which came into being in the first half of 2014, caused a marked slowdown at the lower and mid levels of the market, but of course has little impact in relation to the higher levels. The general election and the uncertainty of any new taxes to be introduced no matter who gets in, and these would be over and above those that we've already seen introduced by the Autumn Statement or previous Finance Acts, is causing some uncertainty in the market. The exchange rate of sterling against the euro has affected the European investor, and in particular those looking to move cash assets out of Europe into the UK. As a general rule, the rental market and in central London and the commuter towns has seen an increase in rent of approximately 1.8%, with the strongest rental growth seen in central London, and those city markets and commuter belts in the likes of Guildford, Tunbridge Wells and Winchester. The young professionals priced out of purchasing have given rise to an active rental market in the 1 and 2 bedroom units, although the larger properties of 6 bedrooms and more have not seen the increase in rental income unless they are located close to a good school. Savills are predicting a rental rise in prime central London of around 17.5% for the 5 years to 2019, and in the commuter zone a rental rise of about 15.9% for the same period. I'd like to just touch quickly on agricultural land. 2014 saw a rate rise in prime arable farmland to approximately £10,000 per acre, although there is a widening gap in prices between England and Scotland. So, who is buying what and where are they buying? Without generalizing too much, it's interesting to view the buying habits of various jurisdictions. Increasingly, motivation for investment has a few common themes. Immigration and the amendments to the Tier 1 Investor Programme, which increased the level of investment from 1 to 2 million in October of last year, has not seen a reduction in the number of applications, the highest number coming from China, but all visa applicants must satisfy certain residence criteria, which will require investment into UK residential real estate, whether as a capital asset or in the rental market. Education is another motivator, and it's either for their own children or investment into student housing. The rising middle classes of Asia and Africa have a high disposable income to invest in a safe economy with other investment criteria, which I will come to shortly. Interestingly, those advisors of Africa, European, North American and Asian high net worth individuals expect to see a growth in the number of those individuals investing in UK residential market, whether for lifestyle or investment in the next year. This is probably due to lifestyle. So moving on to particular areas of jurisdiction and the buying habits of those areas. If I first look at the Far East, the Far East are not acquiring trophy properties at this time. They're buying typically off-plan investments between £350 and £1 million, but they are buying several of them. Their preference is for Zone 1 or 2 or university towns, but the purchaser will usually look to flip the contract before completion for a profit, or if they do complete the transaction, that property is immediately rented out. And they do buy in personal names and quite often with a mortgage. There is no structuring involved from a tax perspective, but they are somewhat naive about inheritance tax, which I'll come on to later. The African market has seen, as I've mentioned, a growth in the middle classes, and we're seeing some acquisitions of trophy properties by those oil-rich nations, and properties in the £1 to £3 million for immigration and education purposes. We have seen some investment into student housing and in commercial property, but we expect to see larger volumes from Africa over the next 5 years. So Russia and New Europe, and by New Europe I mean those countries affiliated with a European lifestyle. The preference of those buyers is traditionally to acquire properties over £2 million and in prime central London, such as Mayfair and Belgravia. With the political uncertainty in the home region, immigration is a priority, as is education, whether on a school level basis or at university level. These buyers usually buy either a tired property or a refurbished property, which could be a flat or a house, but in nearly all cases the properties are completely refurbished once purchased. These buyers are security conscious, so any property will have a high level of security, and further, the use of a nominee to acquire the property is prevalent. This means that the client's name does not appear on the land registry and will usually require tax and structuring advice on a legal and accounting basis. The Middle East have been investing in UK residential for many decades, with a rise of their investment levels over the past 5 years, probably due to currency exchange rates. The typical Middle East purchaser would buy in Zone 1 for an investment or over $2 million for family use. The property will be retained within the family structure for many years, and in recent times we've seen a rise in the use of Islamic financing to acquire the property. This has certain advantages for the clients, both culturally and in keeping their name off the land registry. In recent times we've also seen increased Middle East investment into investment properties for development, commercial and student housing. There's a move towards mixed-use property to hedge the capital and yield rates in the uncertain market as we move towards the general election. In Europe, since the introduction of the French wealth tax, we've seen a number of clients from France looking to move lock, stock and barrel into the UK, and this obviously would require a residential property as a home, together with tax advice. The UK buyer traditionally buys for personal use. The mortgage affordability test has impacted on the UK market as a whole, and given the cost of moving is high, the main motivations for UK transactions are schooling, births, deaths, marriage and divorce, and of course job relocation. Interestingly, in the last couple of years we've seen an influx of German investors investing in the prime rental sector and student accommodation, which given the German market is primarily a society of renters is probably hardly surprising. So what are the issues for investors into UK residential? The leasehold system in the UK has been misunderstood and is not easily accepted by overseas investors. In general, the market in prime central London requires a rapid transaction, and our advice to clients who are selling is to prepare their pack of documents before they launch the property onto the market to ensure that any buyer is tied into a contract as quickly as possible without losing either confidence or motivation. I do not propose to go into the conveyancing process at this time, but some of the issues we have come across with a tendency to delay a transaction include lack of paperwork for consents, planning, etc., title issues such as rights of way, access rights, and missing land areas, the inclusion of separate bank lawyers, and generally sometimes the client's unrealistic expectation of timescale where they tie up a transaction deal and then look at the issues of tax structuring and their own ability to purchase in the UK. So other complications for leasehold properties. Well, the leasehold properties, as I've said previously, are not easily understood by a foreign purchaser, particularly where a lease length is short, and short for means different things for different people. The UK considers short to be anything less than 100 years, and the Far East tends to think short is less than 999 years. That's probably due to the off-plan acquisitions. However, there are investors who particularly look for short lease properties as an investment because they are au fait with enfranchisement legislation and the potential uplift in capital values this can provide. Obviously, these leasehold properties tend to be in the prime areas of central London. It's a complicated area of law and specialist advice should be taken. The costs of leasehold properties. The purchasers looking to acquire an investment leasehold should consider the cost of landlord's consent, especially if consent is required every time the property is let. The cost can be unpalatable as it reduces the yield. The costs of other consent may also be unpalatable, such as where a lease has an absolute covenant on alterations. Recent experience has shown that landlords are now extracting a premium which has no transparency as to its calculation, but of course there is no reasonableness provision in the lease for this consent, and the landlord can charge what they like. Mixed-use properties can prove profitable with a balance between a good yield from the commercial, balanced with capital growth from residential. However, the purchase of such a property may be fettered by the Landlord and Tenant Act 1987, which requires that the current owner, save for several exceptions, must serve a notice on the tenants offering to sell that interest, which may delay matters by 2 months or more. As a side, I should mention that the 87 Act from a lawyer's point of view is probably one of the worst pieces of drafting anybody could ever wish to see, and therefore specialist advice should be taken because there are many slip-ups between service of the notice and the actual acquisition or disposal. Enfranchisement. An investor in leasehold property or indeed a freehold property must accept that there is a risk of losing the freehold or all or part of their reversions under the Leasehold Reform, Housing and Urban Development Act 1993 or indeed the Leasehold Reform Act 1967. As stated previously, some shorter lease properties do offer a good investment, although long-term, and subject to obtaining specific and specialist advice, the acquisition of commercial premises that could be residential offer an investor an opportunity to acquire a freehold property subject to some strategic legal manoeuvring. Alistair will talk about permitted development rights for change of use following my discussion. I should say that some of the landed estates in central London, such as Grosvenor, have introduced a scheme whereby commercial properties, such as those on Park Lane, and those that have been in the past been used for embassies, will sell you the commercial property, but the buyer is required to convert the asset to residential, pay for the renovation, and go through a series of transactions, after which Grosvenor will grant a 155-year lease or a 125-year lease for the property. But the lease will be excluded from the enfranchisement legislation. In other words, you cannot acquire the freehold. It should be remembered that the Crown Estate are an exempt landlord for the purposes of enfranchisement, although they follow the Act by analogy, save for what is known as the accepted areas. These are traditionally around the royal palaces, such as at Regent's Park and St James' Park. In these areas, the Crown Estate will grant a 125-year lease for flats or houses, and there is an active market in that product. However, it remains to be seen whether Grosvenor's estate's 125-year lease will appeal to the market to the same extent. Investors are always cautious about management of leases because there are complications such as service charge or management disputes, which can be troublesome to investors who for that reason may decide to look to invest in freehold properties. Shorter tenancies, or ASTs, assured short-hold tenancies. The investor who is renting should now be aware that an AST limit has increased to 100,000, and of course if the tenant is a company it cannot enter into an AST, it would just be a contractual tenancy. An AST and the increase in level has the advantage of protecting a landlord if they need to seek possession under the accelerated procedure route, but also protects the tenant by placing the deposit within the tenant's deposit scheme. Failing to observe the rules of the deposit scheme may have detrimental effect in relation to claiming possession if the tenant's in breach of the terms of their tenancy, so you should be aware of these issues. In relation to freeholds, the complications usually relate to the management of any leasehold flats in a building. However, where an investor is acquiring a leasehold property, they need to take special advice on the potential acquisition of the freehold under the enfranchisement legislation, and the advice must consider the actual lease, the user provisions in the lease, and the actual use of the property at the time any claim is made. One of the recent and overwhelming complications for some clients are the taxes imposed on residential property by the government. There seems to have been a number of these over the last year or so, and in particular these relate to residential properties held by either corporate or the expression non-natural person or overseas residents. If I deal with ATED, this is to be varied from April the 1st this year to bring in property valued at over £1 million, and it is our experience that this has not had the same de-enveloping procedures that the introduction of the original ATED produced. Stamp duty land tax is now 15% for corporate purchases over £500,000. There are some reliefs, and of course the new rates of SDLT were introduced in December 2014, which has, as I've said previously, reduced the transactional levels. Capital gains tax is payable under the ATED regime, but will also now be payable by non-residents for any disposals after 6 April. It should be remembered this means there is a rebasing of values as of 6 April, and our advice to non-resident clients who have either de-enveloped and or are holding properties in their own name is to look at whether the property should be valued as of 6 April. Income tax is payable on rental income, although I have heard many stories from investors who consider their first-class flights from Hong Kong to be deductible. I'm afraid to say that they are not. Inheritance tax is misunderstood by many non-residents, but simply put, any UK-cited assets, such as a property, are subject to UK inheritance tax of 40% over the current limit of £325,000. We would advise taking advice and also potentially making a UK will. So are there any solutions? Short lease properties subject to qualification can be extended, and a buyer client can take advice on the enfranchisement legislation either before selling or buying. As I've said previously, it is a specialist area and you should consult a specialist practitioner. The consent costs relating to leasehold management issues are considered admin costs depending on the wording in the lease. And if that is the case, they must be reasonable under the terms of the Commonhold Leasehold Reform Act 2002, and as such can be challenged at the first-tier tribunal. We would caution such an application, as any application in itself is not a cheap exercise, but the threat can sometimes prove constructive in any negotiations to reduce the costs. If there is absolute covenants in the lease against alterations, these can be amended by agreement under a deed of variation. But should the landlord fail to agree, I hate to say it, but the buyer tenant should just understand their obligations under the lease and make financial provision for them if they are intending to carry out any works. So the big one, the taxes. I'm afraid there is no easy answer to this one, and the only thing I can recommend is that a good tax lawyer should be consulted. That's all for me. Thank you for your time. I'm going to hand over to Alistair.
Right, good afternoon everyone. Let's not forget questions at the end. We've had 2 in so far. Thank you very much for those. We should have some time at the end for those, perhaps maybe 3 or 4, so please do keep on firing them in. We're going to talk about 5 themes, and we thought actually the way to discuss this is winning planning permission, because we're not about losing, we're about winning, and winning planning permission for high-value resi. We say in the UK, I think, broadly speaking, we're probably all thinking that actually, whilst it's UK, which continues to be a very safe planning environment to invest in, what we're really talking about certainly is central London, parts of the southeast, and some provincial cities where there are things like high-end football clubs. Right, let's take these themes. The first theme here really is about merging units, and certainly as a team here, we've seen more of this in the past kind of couple of years. And the merging of units or amalgamation is increasingly common in parts of Westminster City and parts of Kensington, Chelsea, and also Islington. And what we're talking about are horizontal or vertical amalgamation of units. So taking what used to be 1 or 2 bed, in some people's eyes, slightly small pokey units and making them into larger units to accommodate a kind of 21st century family style of living, 21st century space. But planning permission is actually going to be required, we think, on many occasions for this, and so it's what we've been finding in Westminster, because it is a material change of use. What you're doing, you are knocking out residential units and merging them into one. So if we take an example of 3 units side by side, ripping them out internally is bringing about a material change of use. So that's going to require planning permission. And once you're in the planning permission arena, that's when you will need to be aware of and alert to policy changes with a council seeking to resist loss of residential units. Now, in Kensington and Chelsea, they have a peculiar approach. In Westminster, they did, up until about 12, 13 months ago, they had an amenable approach, which was to allow it. In the past 12, 13 months, it's becoming more common to refuse them. And certainly at the moment, we have 3 appeals in, all of which I'm doing with Elaine and her team. And that could be an interesting outcome, I think. Generally speaking, Westminster are now seeking to refuse all amalgamation of unit schemes. because what they want to prevent is the loss of any residential units. Previously, a kind of common rule of thumb would be that if it was the loss of 5 or more units, then they would seek to refuse that, but they're now looking to stop any kind of amalgamation of units. And that happens in new schemes, certainly by way of attaching conditions which prevent amalgamation, or by way of Section 106 obligations as well, which prevent amalgamation. But of course, there are benefits of amalgamation. That's very much part of your planning case, because in addition to the ability to being about to tart up the interior of the units when you create a larger unit, there are actually benefits in a societal or a family sense, because what you are doing, admittedly at high-end net worth individual level, you are creating a family-sized space. And certainly in the cases that we've won, that argument has gone down very, very well. The argument being you're creating 21st century space for 21st century families. That's the first theme. The second theme has been the really contentious one that came about in November, December last year with a vacant building credit. And this is I think, a 2 or 3 line paragraph in a policy document from government that was released last year. And it came to light in London in mid-January 2015 when, at a Westminster City Council planning meeting, officers reported that whilst previously a viability study had illustrated that a developer was happy to pay £18 million contribution towards affordable housing, the impact of the vacant building credit halved that sum, and the developer was entitled to rely upon the vacant building credit. So in the space of 2 minutes, Westminster lost out on over £9 million of affordable housing contribution. There was, I think, genuine shock and awe in the room at what was happening. Since then has been a kind of vigorous lobbying campaign where people are lobbying to get it changed. Now the intent behind this, the intent is to bring vacant buildings back into use. And the intent in bringing those back into use is to provide more housing. Government recognises that there are issues as to viability, so what government has been seeking to do via this kind of one-size-fits-all approach, I think, is to encourage people to bring the buildings back into use and not pay large affordable housing contributions. You get a credit for it. But not every city in England and Wales has such viability problems. In London, we need little encouragement to bring buildings back into residential use or to transform them into residential use. And the issue in London has been that you have active developers who, over the passage of time, have always been willing to enter into negotiations to viability and produce an element of affordable housing. Those developers who want to play their part in building a stronger city, who want to play their part in providing homes for the future, are now quirkily entitled to halve or not pay any affordable housing contributions in some scenarios. That's clearly not what government intended. And I think whilst government has singly announced that it believes that the policy is a correct one, they are open to negotiations and open to comments on policy, and I would take a punt that post-election, so by the end of July this year, there'll be a policy change for London and the South East, certainly London, I think. So is it here to stay? I think as a policy it is, but I think we may get a carve-out for London. That's the second theme. The third theme is affordable housing off-site. Now, I think we all know that any residential development, certainly high-end residential development, will come with affordable housing requirements. Government conveniently forgets that back in the mid-late 1970s, it was the UK's biggest house builder. So the affordable housing requirements is now all produced by the private sector. So it is inevitable that you have this stepped or phased approach that when you're promoting residential development, you want to, the planning authority will want to see affordable housing on-site. If you can't, or there isn't enough of it, it can be off-site. And only at that point, if you can't provide it off-site, will it take a commuted sum. But councils in central London certainly don't want the money because they can't afford to buy the land is so scarce. So we are in a situation where they do want to see it on-site, certainly if not on-site, then off-site. Now the off-site provision can be an attractive option for developers. It can improve viability of the main scheme. You remove yourself from site constraints about mixing affordable housing and market housing in the same blocks, which go to management issues. And the way in which we know affordable housing is secured is by way of Section 106 obligations. Now, off-site affordable housing, you will have a decant or a donor site, which you have to buy up, and you will either transfer the land or the end product housing to an RP, perhaps as well sometimes with a commuted sum. The issue here, of course, is that there's now a high demand for donor or decant sites, such that there's a real market stress, certainly in zones 1 and 2, that there is not enough land to accommodate the off-site affordable housing provision, which is becoming increasingly expensive to provide. There is a kind of horrible Dante's kind of ninth series of hell here. I'm not sure whether we're all going to be ending up, but certainly even the donor and decant sites now are becoming very expensive to purchase. And of course you also need to think about where will the donor site be, preferably in the same ward, and preferably as well, certainly within Westminster and in K&C, part of Islington. What the boroughs want, they certainly do not want to see wards becoming overpopulated by decant affordable housing sites. So that applies more pressure on the search. And certainly in terms of provision and phasing, I think in every scheme that we've been working on as a team with our clients in the past 4 years, it is always the case that the off-site affordable housing has to be done up front. So you have to have a tighter delivery program, because only when that is in place and available for occupation will the council be happy that the market housing can be occupied. Fourth theme here, and it's one certainly close to our hearts, is basement conversions. Well, you can't go up, you've got to go down. Is it PD or is planning permission required? Well, there is an element of subterranean development which will be PD, where you're going straight down, perhaps one level, and you're not pushing out at the rear or pushing out at the front of the building. But the scale that we're talking about, the schemes that we've been doing with a range of clients on the private wealth side and also with commercial developers, we've been putting in large schemes for subterranean development. And that surge in applications certainly has seen, I think, a quadrupling of schemes certainly in K&C in Westminster and Islington over the past 3 or 4 or 5 years, certainly the past 3 years. There's been a huge number of applications. That's resulted in policy changes, and there are now more material considerations which, as a matter of policy, have to be considered, which can lead to refusal. Structural stability of the building itself and adjoining buildings, flooding, impact on listed buildings, impact on trees in a conservation area, tree protection measures, amenity. Actually, some of these schemes can take 1.5 to 2 years to build out and complete, which is a very significant construction impact. And there have been 2 refusals in central London recently, which have not yet been challenged, which have not yet gone to appeal, where there have been refusals based on the long-term construction impacts. At the forefront of councillors' minds and planning authorities' minds is the fact that if these developments go wrong, there can be very significant damages claims, very significant insurance claims, which is why we've seen a policy trend about putting limits on how far down you go, how far back you can go into the garden, and how far at the front. And of course as well, the cost issue of sill now applies, which adds some extra spice and add some extra cost to the scenario. And I think possibly if you look ahead 2 years, I think the era of subterranean development has pretty much come to an end at the surge in the way it was happening, and it's becoming less frequent. So the fifth, final theme we've got is commercial to resi. So this was the injection into the housing market that government wanted to see, and it was introduced in May 2013. Now across London, there are 33 areas within 17 local authorities where there are exemptions where you can't use PD office to resi. And that's because those authorities sought exemptions on the basis that what they didn't want to lose was office accommodation. But what kind of things do you have to consider here? Well, it's establishing the existing office use. How recent was it? Was it really office use? Was it across the entirety of the building? The physical feasibility. Actually, how easy is it to transform this knackered old building into a residential use? Quite possibly not that easy. Financial viability. Certainly in central London, what we have seen is the land values for resi now are so high, it is financially viable and it's worth doing. In lesser locations, as you move out through zones 2, 3 and 4, it's less so, and I think even with land values for residential land being what they are, it becomes less attractive. But I think finally on this point, before handing over to Lawrence, look to window of opportunity. The rules are due to run out at the end of May next year. Before Christmas last year, there was a consultation when government is considering pushing that date further out and actually removing the date. As yet, we don't know the outcome of the consultation, but I think, again, I'd imagine by the end of July, keep your eyes and ears alert to the fact that perhaps those PD rights will be continued indefinitely. And those are my 5 themes. Keep the questions coming in. Lawrence, over to you.
Thank you, Alistair. We'll be picking up questions at the end with Alistair to make sure that we cover all the points as your questions come in. I'm going to focus very much on the building phase of the projects, touching on refurbishment, party walls, and other common construction issues. So very much the build end of the process. So let's start off by looking at typical projects, which include purchasing, investing, and or renovating property. And of course, these projects can vary wildly in size and cost. Depending on the nature of the project, the client may want no, some, or complete involvement on the project. And in order to achieve that, and indeed advise as to what level of involvement of the client is appropriate, it's important to put the right contractual structure in place, including advising the client when perhaps the structure is not suitable for their development. You need to make sure the right consents and permissions are in place, such as planning permission and issues that Alistair has already touched on, and indeed the thorny topic of the party wall award. Another area you need to be available of is the area of statutory obligations and the introduction of the new CDM regulations from the 6th of April 2015, and wherever there's new legislation, usually confusion reigns. So we need to address that. Also, the regulations and statutes that might apply to the nature of your building contract, regardless of what is incorporated in the written agreement, and that might override contents of the building contract. So let's have a look at the methods of building procurement. We'll split those into traditional, where the responsibility for the workmanship sits with the contractor or the builder, but the professionals such as architect and engineer maintain the responsibility for the design. The more modern and most popular method of contracting, which is that of design and build, and places all the contractual responsibility on the builder, the contractor, and two much less common methods of procurement, being management construction and construction management, which I'll just touch on briefly. In relation to traditional procurement, you will see, as I've just said, that the contractor will take the responsibility to build the project, but most of the time the professional design will sit with the architect, the engineer, and other design input. Do be careful where in these projects there can be a distinction between the role of the architect and the interior designer. Make sure if both are involved that their scope is clear and the coordination between them is also clear. Otherwise trouble lies ahead. Regarding design and build, and you'll see from the slide that the structure is somewhat different, then the contractor is going to be primarily responsible for the design, and those sorts of issues will be passed on. Where this is critical is in relation to insurance issues. Clearly, design liability is likely to be an insurable risk, and as a result of that, you want to make sure at the outset that correct coverage is in place. We'll move on now to the hot topic, just touching on management contracting. Those sorts of models are generally seen as secondary models when projects are in distress, where you have key subcontract packages that need to be a priority. So I don't intend to dwell on either of those options other than to make you aware of their existence, because I would suspect that 95 to 99% of all projects will either be under the form of traditional build or under the form of design and build. One thing obviously to be aware of before we move on to the CBM 2015 issues is in relation to the legislation and how that may affect matters, but I'll come back to that a little later. Regarding the CDM 2015, this is a new regulation that comes in on the 6th of April 2015. Under the previous regulations in 2007, domestic clients did not have any duties. That is going to change fairly imminently, and the extent of those duties will depend on whether there is more than one contractor or main contractor on the project. Now, the majority of domestic client duties will automatically transfer to contractors and designers, although limited duties will remain. So we are, of course, as is inevitable in the context of some new regulations, going to have a transition period. So if a project commences after the 6th of April, CDM 2015 will apply. If it is practically complete by the 6th of April 2015, then CDM 2015 will not apply. In the middle ground, there will be transitional regulations in Schedule 4 of the regulations which will cover this period. And one needs to be very careful about this. It's relatively uncertain as to how those are going to operate, but certainly make sure that the contractual structure is there so that the contractor has the suitable responsibilities. There are some concerns in the insurance world as to how those particular responsibilities are going to be dealt with regarding issues under CDM such as health, safety and welfare, but the best advice at this stage when these regulations are coming in is to be fully aware of those and make sure that you make allowance for those provisions. I'll next move on to the Party Wall Act, often an act which causes much excitement. Indeed, as coincidence will have it, only yesterday a senior colleague came into my room showing me rather attractive photographs of his dwelling and showing that building works were happening next to his house, and he was slightly concerned that by the time he got home his house wouldn't be there anymore, as a result of which I suggested that he might like to speak to his neighbour about a party wall surveyor and a party wall award, and within 3 hours he had a letter from a party wall surveyor, and the building works next door had miraculously ceased to continue. So it is quite an important area, and whilst I appreciate you may not be in a position where your work neighbours are going to come charging in your room with distressed photographs of their domestic dwelling, then I think that we have to be sure that we understand fully what the position is. Regarding the Party Wall Act, as you will see from the slide, it governs work carried out directly to existing party walls or structures, a new building at or astride of the boundary line between the parties, or indeed relatively close, within 3 to 6 metres of a neighbouring building. It sets out the procedure for agreeing work on party walls between building owner and adjoining owner, and it is not something that you can opt out of. If a party carrying out work ignores it, an entire project might be halted and offending works removed. There are a significant number of recent cases on party wall issues. One thing that is absolutely clear is that the costs of those cases nearly always seem to massively outweigh the issues at stake, and therefore that in itself is a good reason to make sure that you comply with the Party Wall Act. It can lead to demolition of buildings half built. It can lead to trespass. Certainly Alistair and I are working on a number of matters at the moment which cut across both planning and construction issues, and certainly if you are involved in a project or neighbouring a project which is causing you concern and you have any doubt as to whether the Act applies, do make sure that you seek advice and contact a party wall surveyor for your own benefit, comfort and a successful project. I'm now going to move on to common construction issues in disputes. As we've covered some of the issues that might prevent disputes happening, unfortunately, in the nature of construction engineering projects and their complexities, disputes do occur. Obviously, it's sensible to try and get these disputes dealt with as quickly as possible to minimise costs, and be aware this is one of the areas where the legislation comes into play. In the land of construction and engineering, in many cases, although this may be covered in the contract in any event if you're using an amended standard form of contract, there will be a provision for adjudication as a process for contractual dispute resolution, which is a fast-track 28-day dispute resolution process which reaches an award which is interim but generally binding and enforceable. Let's just have a quick word about areas of disputes. Needless to say, most disputes ultimately relate to money, but they tend to divide into categories. Clearly, with complex projects, defects are a major issue, as are delays. Defects disputes often occur when works to a high specification. And when you are dealing with high-end residential or high-end finish premises, there are often issues in relation to the level of detail within the contract document and the quality of the finish. There will be notice requirements in the contract regarding notification of defects and timescales to fix those defects, and the possibility of getting someone else in to carry out the works in the event that your existing builder is not capable or able to do that. The notice provisions in contracts are in there for a reason, and failure to comply with them can cause some distress and eventual litigation, because you may have the right to put the work right because it's defective, but if you do not follow the necessary procedures in the contract, there may be issues as to your entitlement to recover losses as a result of endeavouring to exercise that right. Delay, a hot area for disputes. Clearly, one of the main drivers of a building contract is to ensure that there is a timescale both from the point of funding and ultimate occupation. be aware that delay may not always be the builder's fault. Sometimes it's the client's fault. If you as a client or acting for a client note that there are a number of variations, changes, alterations, which is often the case with a high-end residential development, those changes in design will have a consequence, usually in cost, usually in time, and it's important that you advise the client, if you're involved in such things, of the potential consequences of any changes in the specification. Sometimes it's outside the builder's control, such as floods and riots obviously being a somewhat extreme example of that, but exceptionally adverse weather is a more common neutral event which entitles for more time, if not money. So do check what the contract says. There should be notifications of delay. There are different remedies depending on the cause of delay, but always check because it's critical to work out what's happening. Now, some other common construction issues: not applying for listed building consent. I think, bearing in mind the time available, all I would say on that is make sure that you don't fall foul of that particular requirement, or you may find a very expensive ripping down of buildings and starting all over again. There have been recent cases where if you combine costs and the cost of that work, that managed to lose a party circa £500,000. So that should give you an indication to try and avoid that particular route. Basement conversions, obviously Alistair's touched on that. There is an area here where obviously you don't want your new guests in your property to end up in the basement while walking past the building rather than entering in it through the normal route. There are issues regarding capability of engineers to design these conversions, so please be careful. They do require various consents, as Alistair's touched upon, and clearly structural issues are important. Nuisance. This is nuisance in the legal term. There are lots of things, as we all know, that are nuisances, but in certain circumstances, such as in the areas of excessive noise or odours from such things as water treatment plants and drainage systems that are occurring on neighbouring premises, you may have a claim if this is affecting your property, but it is dependent on the facts and it needs to be an extreme set of circumstances. So that's a relatively whistle-stop tour through issues on the construction side. I'm now going to hand back to Alistair, who's going to deal with the questions that have come in during the course of this webinar.
Trip, thanks very much. Lawrence? Right. Thanks very much. Lawrence? Right. We've got 6 questions, only got time for I think probably 2 or 3. Elaine, I'm going to give you a question first, if I may. It's quite a good one, actually. I like this one. In terms of high-end residential investment, do you, Elaine, do you think the UK will continue to attract overseas money to the same degree as in recent years, or do you think it will be overtaken by other markets within Europe or perhaps internationally? Thoughts, please.
Interesting. I think generally the reason for investment into the UK has been, as I've said in my talk, for immigration education. There is obviously interest in the UK from an investment point of view as well. I think depending on what happens in the general election, any new taxes, that might have an impact. I think for most people investing in high-end, it usually is for lifestyle reasons. Obviously, some of the European markets will be affected by the strengthening of the pound against the euro. And generally, there is talk about good bargains to be had in the US. And I think Spain is still looking very attractive from a price point of view because they haven't recovered as well as, let's say, the UK has. There has been quite a bit of investment outside London because London pounds per square foot has got so expensive that they're now looking at places like Bath and the university towns. So I don't think it's going to fall away. I think there might be some consideration depending on what happens with the general election.
Okay. Okay, thanks very much. Lawrence, I'm going to turn to you now, please. Nice, short, pithy question. How do I ensure that I get the high standard of finish of my project? I'll probably start by saying pay your bills, but any thoughts you have, please?
Certainly that's a factor, and I'll try and be as pithy in my response as was the questioner. The issue here is that standard form construction contracts don't tend to make great play of the level of finish. So certainly I would advise that in relation to these items, if you do require a higher finish, make sure that the specification expressly states those requirements. If it's high-end residential quality finish, say so in writing. If you are looking at particular levels of products, make sure that you have a clear sample sign-off process so that, for example, the quality of the stonework or the joinery by way of sampling of finish is of a level where you can do your best to control the quality of the end product. So the moral behind this is make sure that your contracts are sufficiently robust to ensure that they provide for a top quality finish, and that goes alongside obviously the professionals and those involved having the necessary expertise to ensure that the subcontractors and the suppliers are able to provide the products and have a track record in that level of completion. Thank you.
Okay, so we've got time for one more question. I'm going to pick one that I can answer, if that's all right. So in light of recent planning changes regarding the change of use from commercial to resi in London, someone said, do you see the trend moving into the regions, and could this ultimately have a detrimental effect on the commercial property market? Or actually putting it a different way, perhaps my own spin on it, will this push residential investors into the regions? Well, speaking as a Geordie, originally by birth, but someone who's been in London 22 years, I am always struck by how London is just unique, and it operates on its own cycle, something akin to Monaco, the way that it sits within France. I think there will be an effect in the regions. I think the effect that we're going to have is that those office locations which in large cities like Manchester, Birmingham, Leeds, York, Newcastle, Bath, Bristol, Cambridge, Oxford, the need for housing is just so great now in the UK that to carry on building the countryside is not going to be enough, and it is going to be a big push into commercial development turning into resi. It's also the case that apart from major city locations now, people work differently, people work in a different way, and the need for these large office developments beyond central London, beyond central city locations just isn't there anymore. So I suspect the housing demand is there across the UK. I think we will see it developing in the regions. And London, again, exists on its own terms, and I think in London we have a policy environment now where commercial buildings are protected, and that's very, very important. So I think London will continue under its own steam, and out in the regions, yes, it will be spreading, and I imagine over the next 5 to 10 years. And that, I'm sorry to say, is coming up at 2 o'clock. We've had 4 excellent webinars with our host, Henry Stewart. All of those 4 can be viewed on Henry Stewart's website. It's been a delight taking the questions. It's been a delight having you listen to us. I wish you all the very best for the afternoon. Thanks ever so much.